This video concerns judicial review and the impact that it has had on the work of government and parliament. Before we go any further, let's have a look at what judicial review is. Judicial review is when a senior judge or senior judges clarify the legal meaning of a specific law or regulation, or review appeal cases previously heard at lower courts. So essentially what the court is doing is interpreting whether individual acts of parliament or the actions of government are legal according to both UK law and the European Convention of Human Rights, but also whether decisions made at lower court level are in fact correct. Now, this has meant that in recent years, especially since the creation of the Supreme Court as a result of the Constitutional Reform Act of 2005, it's meant that the judiciary has become more active, and some have argued too much. When we compare it with the USA, judicial review is less effective because of the principle of parliamentary sovereignty, and because of the supremacy of statute law, acts of parliament, and because essentially the Supreme Court can't strike down a law. Judicial review is less significant in the UK than it is in the United States. So first of all, let's look at the impact on the work of government. In the top left-hand corner, you can see at the time of creating this video, the Lord Chancellor, Dominic Raab. Now, the Constitutional Reform Act, the creation of the Supreme Court, and the process for appointing Supreme Court justices has reduced the role of the Lord Chancellor. So there's one impact on the role of government. The Lord Chancellor has less formal powers than they used to. And on the right, you can see the rights afforded to us thanks to the European Convention on Human Rights. So from right to life, right not to be tortured, and so on and so forth. And those cases where the Supreme Court judges the policy of government against the European Convention of Human Rights can challenge the work of the executive. But it's not all one-way traffic. The physical relocation of the Supreme Court just across Parliament Square from Westminster, that physical relocation was symbolic, but practically the relationship between the judiciary and the other branches of government hasn't particularly changed that significantly. And another thing that we've seen in previous cases, and if you've watched previous videos, you will know what I am referring to, we've also got cases where the government can retrospectively change legislation to essentially nullify any legal argument that the executive had been acting ultra vires in the past. So there are ways for the executive to get around previous cases. Now let's look at the impact of the work on Parliament. We talked about the Constitutional Reform Act in the last slide, and we need to talk about it here as well. The Constitutional Reform Act removed judges from the House of Lords and ensured a separation of the legislature from the judiciary. And hearing cases under the European Convention of Human Rights empowers judges to challenge acts of Parliament. Now, there we can see two ways in which judges can impact the work of Parliament, or the two ways that they have impacted the work of Parliament. But there's a limitation as well. A declaration of incompatibility, which is when the Supreme Court judges that UK law is not compatible with the convention, the European Convention of Human Rights. A declaration of incompatibility can't strike down an act of Parliament, and Parliament is in theoretically under no legal obligation to fall into line with the decision. Parliament has to go back and change the law, but the law isn't essentially struck down. So there's a limitation there to the role, the active role that the judiciary can have. And finally, we need to look at some recent changes that have impacted the role of the Supreme Court. One of the issues that people who were in favour of Brexit had with the European Union was that it empowered British judges to essentially cast judgments on British law based on the rulings and the work of the European Union. So we can look at something like the Factortame case, which is a precedent which post-Brexit no longer applies. But that essentially, it was a court case regarding fishing laws. But essentially, what the case judged in 1990 was that the court could suspend the actions of Parliament and the executive if it had been judged to breach EU law. And that was a significant power that the judiciary had. But post-Brexit, of course, that has changed. So that is one way in which post-Brexit we can see the judiciary has become less active than before. And secondly, one thing to consider is that the government, again at the time of creating this video, continues to plan to replace the Human Rights Act with a British Bill of Rights. And replacing the Human Rights Act will, of course, impact the judiciary's job or the judiciary's role in trying to ensure that the European Convention of Human Rights is being followed when the executive is executing the law or when Parliament has passed legislation. So if the Human Rights Act was to be repealed, it's not to say that the European Convention on Human Rights would no longer have any relationship in Britain or with British politics, but it would certainly impact the way in which we judge the actions of Parliament and the executive. So you can see one change that has already happened to limit the court's role and one potential change in the form of the plans to repeal the Human Rights Act.